Welcome to Self-Represented in Family Court, the only podcast you need if you're feeling lost, stuck, or overwhelmed in family court. At Self-Represented, we don't waste time discussing the law like all the other podcasts. We focus on what really matters in your divorce or custody case. That's strategy. With your host, Tracey Bee, former family law attorney turned pro se family court strategist.
If I had a penny, yes, a penny, for every time I heard someone say, I just want this to be over, I don't care anymore, I'll take less, peace is more important than money any day, I would probably be a thousandaire. Not a millionaire, a thousandaire. Yeah, it does happen, but it happens just enough in my watch for me to step in and say, hey, wait, hold that thought. Is this you? If it is, stay tuned. You're going to want to hear this episode. Hey there. I'm all about settling. I'm all about getting things over with. I'm all about living a stress-free life. I'm all for all of the above. But what I'm not all for is people settling when they think they're doing what's best for them or their kids or their future. If you're settling for your peace of mind, then you still should be informed. Make informed decisions about your settlement. Even if it's premature, even if you're sacrificing, even if you're knowingly taking less than what you're entitled to or what you know you can actually get. You know why? Because sometimes once you do, there's no going back. There's no turning back. It's one and done, and that's it. Let's talk about that. Let's talk about what settling just to have a peace of mind should look like. You're settling. Let's talk about settling first. What is settling? Settlement can happen in a number of ways in family court. You can settle your case before you even go to court. You can have a discussion with the other party, your spouse, about what you both want, what you will both agree to, and what you will actually waive or give up in exchange. So having that discussion can look like, hey, we're going to do joint custody, 50-50 custody. You're going to keep your pension. I'm going to keep my pension. You're going to pay this amount in child support. And, we're going to split the house. We're going to sell the house and flip the house. Proceeds 50-50. There you go. Everything's hashed out. Everything's ironed out. You reduce it to writing. You get it, reviewed by respective attorneys, because you should always get your own attorney, both of you, to look at the agreement to ensure that your rights are protected. That's settlement in peace. That's settlement making informed decisions. Because once you have an attorney look at it, the attorney shouldn't charge you for more than an hour. It should cost you both an hour, respectively, to have your attorneys look at it. And then you can sign it and submit it with the divorce papers, and voila, you'll be divorced in a matter of weeks or months, wherever you are, based on wherever you are. Now, that's a peaceful settlement, usually. Sometimes things happen, things change down the line, and of course you want to revisit some of those issues. But that's mainly the way, the closest, if not the only way, to ensure settlement with peace. And I'm going to explain to you why I say that. The other way to settle is you commence an action, and whether it's by requirement or by agreement, you go to mediation and you mediate the issues. Because sometimes trying to do it on your own is not enough. You need a neutral, an objective third party with some knowledge about family law help you iron out the details of your agreement, of your settlement. And that's fine if you can do that. Especially when both parties agree to do mediation, Some jurisdictions you're required to go to mediation once you actually start the divorce process. And then there's some places where it's voluntary. You don't have to, but they highly recommend it because that's the wave of the future, alternative dispute resolution options. And so you go to mediation and the mediator is able to get you both to agree to all the issues: child support, custody, division of property or assets, even debt. And so again, you both either have your respective attorneys already, or you are going to have your respective attorneys review the mediated settlement agreement to ensure that your concerns and your interests are protected. Again, very likely that settlement is going to be a peaceful one. Now, in either scenario, you can still take less than what the court would grant you, right? It's always a gamble. It's always a risk. You can always agree to take less. And if you agree to take less knowingly, that's the key word, knowingly, knowing what you're entitled to, knowing or having an idea of what your judge would do or what the court would do, having an idea of what it would cost you to fight for those things, because that's huge as well, then you have a stronger chance of settling peacefully and not having to deal with the stress or the costs of litigating a case that is not headed toward the direction of settling. How about you settle after mediation because mediation was not successful, or you settle at mediation but you felt forced, or you settled during a hearing because you just couldn't take it anymore, or because you saw the imbalance of power. Maybe you're pro se and the other party has an attorney. Well, these are different. So let's talk about scenarios where settling for less than to maintain peace can be a misnomer, can be a red herring, can be totally opposite of what you think it is. Scenario number 1, you're at mediation with an attorney or not, and you feel that there is an imbalance in power. There might be a history of manipulation, of control, or even abuse. And you have an attorney whose role, especially at mediation, is to not do much, but just to sit there and ensure that your interests are addressed. Having an attorney at mediation doesn't necessarily bode well for a lot of people, because a lot of times the mediation process doesn't allow the attorney to really advocate aggressively on your behalf. Because again, mediation is supposed to be a voluntary experience. It's supposed to be something somewhat peaceful, low conflict, even in high conflict situations. I know that sounds like an oxymoron. It sounds like a setup, actually. And so if you have any of those, history of violence or abuse or an imbalance of power, you have a high conflict divorce case going on, you have an attorney who doesn't really advocate for your interests, not aggressively, just not at all, or you have a mediator. Sometimes mediators are just not good at their job, just like there are bad attorneys, bad teachers, bad officers, bad doctors, they're bad mediators. And so you now feel like it's at the 8th hour, you've been sitting in mediation for 8 hours, and you feel like you can't do this another 8 hours in this environment, in this context, and have to deal with the emotional and the mental strain it causes you. So you settle. You know what you're entitled to because your attorney told you that. You know what the law says because the mediator addressed that. But you just feel like you can't do it anymore because it's too much for you. You have so many other things going on. You want this to be over. That's not settling for less peacefully. You're not going to have peace because you settled for less in this situation. And yeah, I understand that you have to function and you have a moment of relief, but I can assure you, almost 110%, that you will have some sort of regret, some sort of apprehension and reluctance, some doubt, even some fear creep in somewhere down the line. So you may have your moment of peace, of stress-free, of relief for a month, 2 months, maybe even 6 months. But I can assure you, particularly when there's children involved and or money involved, yes, money involved, you will have some sort of regret. So settling early, sacrificing what you're entitled to for your peace requires that you really think about the long-term impact. Let's take another scenario. You're at the hearing stage. You've been dealing with the opposing party who's been reluctant to turn over discovery and or financial disclosure and supporting documents. And you're at the point where you've tried to get the judge to do something and the judge just doesn't think it's important. And so now you're at the hearing stage and there needs to be determinations made about what you get financially, the visitation schedule, even custody. And although the financial information doesn't have anything to do with custody, the other discovery, the things you requested in your discovery demands might, and they may have an impact on how the custody is determined or even how the visitation schedule goes. So you don't have that, but you're at the point where either you go forward with this hearing or you run the risk of the judge being so upset that you have to drag this case on, or that you may have to spend another $20,000 that you don't have, whatever it is, you decide, you know what, I'm going to move forward with this knowing that I don't have all the information, not understanding that I need that to make an informed decision, but I'm going to do it anyway because I just don't want to deal with this litigation going on any further. I can't afford it. I can't endure it. It will give me some peace to just let it all go and get it over with now. That's not an informed decision. You have no discovery, you have no evidence, you have no proof, you have nothing to really substantiate your claims for whatever it is you're asking for, whatever it is you know your lawyer assured you that you're entitled to. So now you've just made a premature settlement. And it's a little different than the first scenario I gave, because in this one, you may have a little bit more of an influence from the judge or the key players or just the process itself. But I tell people often that they should not allow that to be the tutelage that the courts intended to be. Whether you have an attorney or not, you should still make informed decisions, because if you believe you are forced to make decisions, or you feel like there's some passive influence to get you to make decisions that are not necessarily aligned with what you are entitled to or what you can legally accomplish from your case, then you need to use that information, obtain the information first, and use the information to make better decisions in that particular scenario. So, because at some point, again, a month, 6 months, a year, you're going to regret it. And what recourse you have may be limited if you actually find yourself in that situation where you have regrets. So, definitely something to think about. So, how about scenario number 3? You're at trial. It's not hearings now, it's actually trial. You've hung in there. You've done everything I just suggested. You've made it. You've gotten past that mark. But now you're at trial. And now you realize that this trial is not going to look the way you thought it would look. Your personal life might have changed. Your representation might have changed. The dynamics between you and the other party might have changed. Even something in the court process might have changed. And you feel like, you know what? I am not in the right space or the right position to continue even at trial. Because yes, it happens. A lot of cases settle right at the opening statement of trial, right before opening statements even start sometimes. And that sounds like the ideal situation, right? Because you've gone through discovery, whether it's legitimate or not, whether it's sufficient or not, you've gone through that. You've done motions and hearings and forensics maybe, and got a GAL involved. You've done it all. So you move through the court process the way you should. And so now you're at trial and you're thinking, hey, yes, this is the chance. This is what I've been enduring, all of what I've endured so far. But now you're at the finish line, and for some reason, a monkey wrench has been thrown in your program and you just can't move forward. And you decide, you know what, I'm not going to proceed with trial. I'm not going to do it. I'm going to go ahead and settle. That sounds almost counterintuitive to a lot of people. But for some, it's not. It makes sense. And why does it make sense? Because trial is always a risk. That's why a lot of people wind up settling at trial, because they made it this far because it was part of their strategy to make it this far. And so now they're at that stage and they still decide, hey, you know what? I've accomplished what I set out to accomplish by taking this case to the trial track. And so now here we are. And now, yes, I'm going to resolve this. I'm going to settle. Believe it or not, you can still settle prematurely, sacrificing what you're entitled to at trial, on the day of trial, and still have regrets. You may not have as many regrets because you feel vindicated that you've actually made it this far, that you've gone through the process for this length of time. But there's a chance that you can resolve the case right now and it still be premature because the judge didn't get a chance to hear everything, to address everything, to make its ruling. Because at the end of the day, in every single case, any resolution that is not made by the judge and judges make mistakes, they get it wrong, absolutely, especially in family court a lot. But you have no recourse if you settle the case and the settlement is wrong. You have recourse if the judge makes a ruling and the ruling is wrong. You have what's called the appeal process. So if you settle the case at trial and you do it prematurely, what does premature look like at trial? Again, you know what you're entitled to. Your lawyer or lawyers have been telling you what you're entitled to. You have a great idea of what's at stake. You know all of this. But again, things might have changed for you. Things might have changed that make you say, you know what, it's not worth it, or I'm willing to walk away from it, or I'm not willing to take the risk right now. And you can still decide that, knowing all of that about the strength of your case, the fulfillment of having information, all of those things. But if your situation has changed, the dynamics have changed, something has shifted, and you decide settlement is what's best for you, knowing that you're giving up something important, something significant, then you can still have a certain level of regret. You may have more peace, you may have more relief than having done it earlier in the process, but it's still possible that you may have some level of regret down the line. Let me just say this. You're going to have some regret no matter what. Family court. Nobody wins in family court. Not your children, not you, not the other party, not the affair partners, not maybe the lawyers, maybe the guardian ad litem, but nobody wins. As far as your specific family dynamic, nobody wins. So you're going to have some regrets. But if you can sort of be more enlightened about the possible consequences, the possible regrets, the possible end results, then that may give you some sort of appeasement when it's all said and done. The underlying message is making informed decisions at every stage, whether you decide to give in, give up too soon or not too soon or at the right time. Just make informed decisions when you do that. That's what I advise you. That's what I advise anybody who asks, and I've always advised that, making informed decisions. So anyway, that's what I had for you this week. If you need some help with making informed decisions or learning how to make informed decisions or learning how to use information to your advantage when you're trying to decide if you are going to walk away to maintain your peace or to sacrifice so that you have some relief now or in the future, please feel free to schedule an hour with me and we can talk about it. We can hash out exactly what the issues are. We can discuss exactly what your strategy should be. I can't give you legal advice, but I can give you something better, which is strategic guidance. That's so much more important in family court. And so I am here to do exactly that. If you haven't already, take the diagnostic assessment so that we can get an idea of where you are, what the bottlenecks are in your case, so that you can actually finally get the needle moving and gain some traction and move the case in the direction that you want. So until next time, thank you so much for tuning in, and I look forward to speaking with you next time. Bye.
If you're having an active family court case and something already feels off, you need to identify where your case is seriously exposed. Schedule a strategy session now so we can shield your case from more damage. You can't afford to keep guessing. It's costing you way too much.